Welcome to Chat with the Lawyer. I'm your host, Walla Blagay, and today I'm honored to be with my good friend, Edgar Ndjatou, who is an employment lawyer, and today he's going to talk about your rights in employment law, which is very important. As you know, in this good American society, we all have to have jobs to live, and we need to know our rights in the workplace. So he's going to help us with that today. Welcome.
Thank you, and thank you for having me here.
No problem. Now tell us a little bit about your practice.
Sure. So I am one of the founding partners of McCree Ndjatou PLLC in Washington, D.C. We became a firm about 4 months ago, and I practice primarily employment law. I represent both employers and employees in all matters of employment law, whether it's at the state or federal level. A lot of my work does involve discrimination claims, but I do other types of areas of employment law, such as wage and hour, wage payment, federal employees, so on and so forth.
All right. So let's get into the meaty part, discrimination law. Now we know we all have issues where we're like, look, someone doesn't like me. Maybe it's my race, maybe it's my gender. But you know, sometimes we don't understand quite what discrimination law is, and people use it freely. So explain to us, a little bit about the law.
Sure. So some of the main things people should know about discrimination law is this, that the federal government had instituted in 1964 under the Civil Rights Act something called Title VII, which governs the types of discrimination that is protected in the workplace. And under the federal law, the main characteristics that are protected are national origin, gender or sex, race, which is a big one, and religion. And you have other characteristics as well that are protected under the law, such as age, disability, and pregnancy discrimination. And the federal law covers not only people in Maryland, but all over the country. But then in Maryland, which tends to mimic the federal law, when you look at specific local laws, such as the local discrimination laws in Prince George's County, it tends to be broader in scope. So you have characteristics protected such as marital status, whether you're a student, sexual orientation, which is a big one these days, political affiliation. So it's important that when you look at the laws, look at the federal law and also the local laws, because sometimes the local law, particularly in Prince George's County, can be much broader and can offer much more protections than the federal law.
Okay. Now explain why protected status is important, because many people don't understand that.
Sure. Well, leading up to the passage of the Civil Rights Act of 1964 and Title VII specifically, for many years, as we all know, many types of people were essentially discriminated against in employment. So take, for example, of race. For many years, black people in this country were not able to get certain jobs, or if there weren't certain jobs, they weren't getting paid the same or afforded the same opportunities and benefits to advance in a workplace. So the idea behind Title VII is to make sure that everybody, regardless of their characteristics, and particularly the ones that are protected under the law, have a fair shake when it comes to hiring, when it comes to advancement, and other considerations in the workplace. Okay.
Well, let's get into the evidence area, because it's said that over 70% of plaintiffs lose, EEO cases or EEO claims. So how much evidence, what do you need to prove that you've been discriminated against?
Sure, and that's an excellent question, and that's something as a practitioner that I have to figure out on a daily basis with a lot of my clients. And what I usually tell clients is this. Most places should have an employee manual, and that should be the first thing you do is to read the employee manual, the company handbook, as to how they handle discrimination claims. And the minute you feel that something is off or you feel something is wrong, you should start keeping a narrative of events and making sure that you keep track of what is said to you, what is done to you, decisions that are made that have affected you negatively, I usually tell clients, get a notebook. You can get something inexpensive at Staples, and just jot down notes every day to keep track of things that happen. And I think the most important thing, though, that I have to emphasize is that you need to also show that there's some damage. So it's not enough that you feel that your boss may not like you because of your race or your gender. You also have to show that not only does he not like you because of that protected characteristic, but he's taking actions against you that negatively affect your employment. So whether it's not giving you that raise, but the other person that looks different than you or looks like him gets that raise, or being disciplined unfairly, or being terminated when the other people should have been terminated. Those are things you have to take into account too. So usually when clients come to the office and they tell me their story, the automatic thing I ask is, what's the damage? What did you suffer as a result of the treatment?
Interesting. Well, and also explain if does the employer have to yell a racial slur or call you a certain name in order for you to get relief under the EEO laws?
No, not at all. As a matter of fact, especially now these days where it's not we're not in a society anymore where people show their racism outwardly like they did in the past. So certainly now, in terms of evidence, you have to show that it's about equitable treatment, really. So yes, of course, if your boss is yelling racial epithets or saying certain derogatory things of a sexual nature or whatnot, of course that is a clear case of violations of the discrimination laws. But yeah, exactly. But one of the biggest things we look for as practitioners is we look at the demographics of the workplace, particularly your comparators. Your comparators are people that do the same work as you do, or are managed by the same person that you are alleging is violating the discrimination laws. And when we look at, we have a person who is, let's say, a woman, and she's working with all men, and they seem to have better treatment in the workplace, and she's not. That's what we call a disparate treatment claim. And it does not necessarily involve making jokes about someone's gender. It's about how that person is being treated. And we call that circumstantial evidence, essentially. It's not direct, but it's circumstantial. It raises a doubt as to the employer's equitable treatment of that person. Another way that employment lawyers try to show discrimination is bringing cases that are called disparate impact. Disparate impact cases are cases where an employer's policy negatively affects a certain portion of the workplace. So in the past, a lot of disparate impact cases revolved around testing for certain jobs. So there are classic cases about police officers and firefighters where the way the test was written would keep out many black firefighters or black police officers. So a lot of attorneys would bring disparate impact cases because the argument is, well, we're not saying that you're discriminating against this portion of people directly, but because of this policy, it affects them in a way that is more than, for example, the white applicants. Now, disparate impact cases are not as prevalent anymore. Not to say that they don't happen, but they're not as prevalent because I think that society and employers have gotten smarter as to those forms of racism or discrimination, I should say.
What about hair? Is hair something disparate? As any disparate impact cases come for like hair?
So not that over in recent memory, but let me also kind of explain more about hair. So the federal law does not really cover personal appearance, but the Prince George's County law, discrimination laws, does cover personal appearance, and so does DC law. And the tricky thing about personal appearance is that you have to really look at the person's, you have to take into account cultural sensitivity. Sometimes it borders on religious. So, for example, if you're Sikh and you wear the head wrap, that can fall under personal appearance. So, there have been a lot of cases about that. But now, what a lot of employers do is that they have a blanket personal appearance policy. So, what you should look for in that sort of policy is, if they're saying that, for example, men should not have long hair, so that means that you have to keep your hair short whether you're Caucasian or black. So if you have dreads, you got to keep it neat, or get rid of them completely. And even if you're, let's say, a white male, you cannot have long hair past your shoulders. You still have to keep it neat or keep it close. So as long as the policy applies to everybody, then it's valid. But if an employer starts targeting certain people and does not have a policy that covers everyone, then they expose themselves to liability under the discrimination laws.
Interesting. Well, let's go into remedies, because a lot of people assume that once you have an employment case, you're going to be paid $3-4 million. So explain sort of where you get all different types of remedies and what evidence you might need. I mean, you can touch on that since We've already talked about evidence.
So the main remedies that are available to you under either the federal or local discrimination laws are the following: back pay damages, compensatory or emotional distress damages, and reimbursement of attorney's fees. And I'll go through each one specifically and then talk about other potential damages that you can get under the laws. Back pay essentially is money owed to you had you not been terminated from a position because of discrimination, minus any money you've made in the interim. Okay, so and in the event that, let's say, you were not promoted, then we'll take into account when the promotion should have happened and how much you should have made as a result, and subtract what you're making in the interim. Okay. The key here, and particularly if you've been terminated, is that as a plaintiff, you are under an obligation to continue looking for another job as you pursue a discrimination case. So it's very important that you make sure that you keep track of the money you make in the interim, because that is deducted from your total back pay available to you. So you're left with what we call net back pay.
Interesting.
Okay?
Well, we're going to take a short break, and we're going to come back and talk more about the relief and damages under employment law. So please stay with us. This is important information. Thanks.
So who's going to do what?
I'll pack the dead batteries.
Great.
I'll only put what I don't need into a duffel bag.
Perfect. That's totally unhelpful.
No problem.
Meanwhile, I will try to comfort everyone by speaking in a calm voice. And who is going to handle supplies?
I can forget to do a list for us.
Thanks, pal.
We couldn't be any less prepared. I'm proud of you guys.
Talk to your kids about who to call, where to meet, what to pack. Visit ready.gov/kids for tips and information.
Welcome back to Chat with the Lawyer, and I'm your host, Walla Blagay, and I'm here with Edgar Ndjatou, and we're talking about employment law and remedies. So let's jump back into it. So you were just explaining back pay.
Yes.
So we can go for it.
Yeah, so that's what back pay is. Now, you have other remedies, as I mentioned. We also have what you call emotional distress damages. And what that is humiliation or embarrassment or emotional distress that you suffered as a result of discrimination. And the main way that we try to bring that out is by looking at the sort of treatment you may have received as a result of any trauma you've experienced in the workplace. So usually when a client comes in and says they're stressed out or have anxiety or not sleeping at night, then my immediate question is, are you seeing a healthcare professional that deals with mental health? Because that's an important factor to determine the extent of the emotional distress being suffered. Now, it's important to know that under both federal and local laws, that compensatory damages have a limit. Okay, generally it's $300,000, particularly for a big employer. If you're a smaller employer, that amount is a little lower. So it's important that people understand that it's not a windfall amount you just get.
Sitting on the beach
Right.
for the rest of your life.
It's by statute how much you can get. Now, it's also important to know that as part of a remedy, you can get your attorney's fees reimbursed. Discrimination law is what we call fee shifting. So what that means is that if you're successful in resolving your case, either through private means or in court or at a hearing, you can request that your fees are reimbursed by the employer. So those are the three big categories of remedies available under discrimination laws. And of course, there are others, whether it's feasible by law or by the court, such as reinstatement to a job, for example. That's something some people like to get. So I like to say that as long as the employer can do it or it's something legally that can happen, I'll explore it.
What about pain and suffering? Is that an option under employment law?
So pain and suffering will go under emotional distress damages or compensatory damages. It's sort of the same thing.
All right, well, that's good. Well, then let's even go into some of the other areas of law. Like, let's look at wage and hour. In fact, let's go back. How about talking about looking into religion? Now, what are is there exceptions with religion for employers?
So the main thing people should understand about religious discrimination is that it's sort of, religious discrimination is sort of proven the same way as the other characteristics, in the sense of, an employer cannot treat you differently because you practice a religion or either from them or just in general. Now, one of the differences with religion and also disability discrimination is what we call accommodation. Okay, and in the example of religion, oftentimes people, whether they're Jewish or Christian or Muslim, need to do certain things to practice their faith, whether it's praying 5 times a day, leaving early on a Friday for the Sabbath, attending church services on a Sunday. And as long as you have a good faith belief in your religion, you can request that your employer accommodate your schedule at work so you can attend religious services or practice your faith in the way you see fit. And so the employer has an obligation to explore whether they can give that accommodation, and the only way they can not do it is if they show that it will be an undue burden to their activities. Okay, and the most important thing what you want the employer to do is engage in what we call the interactive process, which is a back and forth between the employer and the employee about what is the best accommodation possible and is it feasible for the employer to do it. And that's the same analysis used in disability cases as well.
Talk about the disability.
Sure, and under the American Disabilities Act, it's similar to Title VII in the sense of you cannot treat someone different because of a handicap, whether you can see it or not see it. Now, some of the biggest cases that happen are what we call reasonable accommodation cases. And similar to religious accommodations, if you have a handicap, whether again seen or unseen, but you can still able to do your job with or without the accommodation, you can make a request to your employer to accommodate you. So whether you're taking medication that prohibits you from driving because it makes you drowsy, whether you need to leave early for medical treatments, whatever the situation is, the employer has to make a good faith effort to see if they can do the accommodation, and the only way they can safely say no under the law is if they can show that it will be an undue burden to their operation.
Okay, all right. And with disability, is there limitations on whether you qualify for the law, whether you can use the law or not, whether you're protected?
Yeah, well, I think the most important thing you have to keep in mind is you have to be a qualified individual with a disability. And what that means is that you have to be able to work at the end of the day. So if your doctor does not release you back to work, or your condition does not allow you to work, because again, the definition is with or without reasonable accommodation. So one of the hallmarks of the law is you have to be able to work, and as long as you have an accommodation, then you'll be able to, of course, fulfill your obligations at work.
Okay, and what if you have a temporary disability, like maybe you fell while you were running or something, and the doctor says, oh, you have a weight restriction for maybe a week or two?
That is still covered. The ADA does cover permanent or temporary disabilities. And another thing you may want to consider is taking what we call Family Medical Leave Act leave. And
Can you talk about that?
Yeah, and the acronym is FMLA, and what that does is it allows employees to take time off for serious medical conditions, whether for themselves or for very close family members. And so in the hypothetical you brought up about, let's say you fell on the job or at home and you needed some time off to care for yourself, you instead of requesting a reasonable accommodation, you can just say, I need some time off to care for myself and to get better. If it turns out that you need an accommodation, then of course you can request one. It's also important to know that under the federal law and also Maryland law, you need to have worked a year with the employer before you can take advantage of FMLA leave. The other important thing you need to know is that you're only allowed up to 12 weeks in a calendar year. So if you go over your 12 weeks, then you may be considered AWOL, or you can get terminated, yes.
Right, and do you know what it is in DC?
In DC, it's what's called a DC FMLA, and that gives you an additional 4 weeks in a calendar year, so that's 16 weeks altogether if you're working, if you're working for a DC employer.
Okay, well that's very interesting. There's so many laws in employment that it's just hard to keep up. But let's go into wage and hour. Now, a lot of people are using this in employment law. It's a growing area. Right. So can you talk a little bit about it?
Sure. So wage and hour essentially covers the payment of employees properly under the federal and local laws. So let me start by saying this. The minimum wage in Maryland and nationally is $7.25 an hour. In Maryland, that is going to change this year. I believe effective July, it's going to go up to $8.25 an hour. So I always tell clients or people in general, just always make sure you check your paychecks or pay stubs to make sure that you're getting paid the appropriate amount of money if you're an hourly employee.
So let's go into the wage and hour law. Now, this is a growing field that everyone has been looking at. There's more claims in this area. So tell us a little bit about it. Sure.
So wage and hour is very important because it basically covers what you take home in your paychecks. So the most important thing people should know right now is in the state of Maryland, the minimum wage is $8 an hour. I believe that was effective this year. So please make sure when you get your pay stubs to check to make sure you're getting paid the right amount of money. In the county, Prince George's County, the minimum wage currently is $8.40. And one thing to know is that at periodic times in the next couple of years, those minimum wages are going to go up. And I believe in Prince George's County, the highest it will go, I believe, is $11 an hour. So you can go online and check the schedule as to when the increases will happen. The other thing you want to make sure is that when you get your pay stubs, that the appropriate payroll taxes are being taken out of your check. That's very important because if they're not, then there might be a question of whether you're actually an employee in the eyes of the employer or an independent contractor.
Now, how would they know how much payroll taxes should be taken out?
So there is not an exact formula that particularly I can extrapolate on, but generally you want to see that your Social Security is being taken out, your FICA taxes are being taken out, and those are the type of things you want to look for in your pay stubs. And if you don't see that being taken out, you want to make sure that your employer is doing it, and if they're not, you want to ask them why. Because again, If they're not, then there might be a question of as to whether you even covered under the wage payment laws, because if you're deemed not an employee, then you might be in some trouble. So what I usually tell clients is make sure that when you walk into a workplace, you know for sure that you're an employee and not an independent contractor. Because when you're an independent contractor, then you're responsible for your own taxes, which is very important to know. So I usually tell people, just make sure you understand what your relationship is to the employer.
Now, is there a test on whether a person is an employee or independent contractor?
Absolutely. As a matter of fact, just because someone says you're an independent contractor doesn't mean you actually are. And there is a test that you can find online within the state or even with the IRS or the U.S. Department of Labor that tells you what to look for. And some of the main things you want to look for are if the employer controls your hours, do they make you wear a uniform, do they tell you when you can take breaks, are you using their tools and facilities to do the work, do you suffer a loss if the work doesn't get done? So those are the type of things you want to look towards in determining your status. So again, just because you're called an independent contractor doesn't necessarily mean that you are, and you want to make sure that you do that test if you're in doubt.
All right, that's good. And is there any other areas in wage and law that we should be aware of?
Overtime is another big thing. And so in the state of Maryland, if you work more than 40 hours in a work week, you're eligible for overtime, which is time and a half, what your original pay is. And most employers should keep track of your overtime hours that you're working and should pay you appropriately. And again, what I usually tell clients is if you're not sure if your employer is keeping track, you want to keep a logbook of your hours worked. So all your straight time worked plus any additional hours you work over those 40 hours. It's very important you do that because on a practical level, I can't tell you how many times I've had clients come in or advise clients or potential clients and they complain that they haven't received overtime, but they have no way of verifying the time worked. And in this area of law, it's very important that you're very specific in the amount of time worked, because if you don't have proper records, then it's hard to convince a court that this person is owed X amount of overtime if we have no way of proving it.
Interesting. Well, we want to thank you so much for coming on this show.
No
it has
problem.
been quite a pleasure. Very, very helpful information. So now if people want to contact you, so tell us how we should contact you.
Sure. So my office number is 202-618-7092. I can also be contacted by email, and that is endjatou@mnlawyerspllc.com.
All right. Well, thank you, Mr. Edgar Ndjatou.
Thank you.
And we're going to have you come back on and talk about some other great stuff like workers' comp and other great
Sure.
issues.
We're glad to do it.
Yes, we're definitely going to do that. So if you want to know more about the show, please contact us at chatwiththelawyer@gmail.com, or you can check out our website at www.wallablegay.com. Thank you.
Protect your unborn baby from CMV, a crippling birth defect virus. CMV disables more children each year than Down syndrome or fetal alcohol syndrome. Learn more at cmvfoundation.org.